When representing a seller in a distressed transaction, there's an important checklist of items to be wary of in order to protect the interest of your client and its officers and directors. This is particularly important where the members of a private equity firm sit on the board of a portfolio company that's in distress and is being sold. First, there are certain categories of corporate obligations which, if unpaid, can result in personal liability for officers and directors. These include unpaid wages and trust taxes such as 941 employee withholding taxes. As to wages, different states take alternative views regarding what constitutes wages. Some states, for example, include benefit obligations such as paid time off. Likewise, certain states include severance payments and some do not. Careful consideration should be paid to the company's cash flow in order to be sure that there's sufficient liquidity through the anticipated closing date of the sale transaction to be sure that such payments are made. State law differs as to who bears the liability if these items are left unpaid. In most cases, liability extends to the person in control, which is often a CEO or CFO, but it can also extend to the board if an evidentiary record which shows that the board had a hand in making decisions on this level. Next, there can also be personal liability for officers and directors if illegal dividends were made. That is, dividends paid to shareholders at a time when the company was insolvent, which can often be the case in distressed M&A transactions. It's important to know that there are risks related to reimbursement of corporate expenses. Sometimes, a distressed transaction will occur in a bankruptcy proceeding, or a bankruptcy proceeding will follow a distressed sale. Under the bankruptcy laws, the trustee and creditors have the ability to claw back certain payments made before the bankruptcy case was filed. For insiders, such as officers and directors, that period extends back for 1 year because they are deemed to be insiders under the bankruptcy code. Hence, officers and directors and private equity firms that are equity sponsors should be wary and understand the risks relating to payments they receive from the company in the year leading up to the bankruptcy filing. These payments can come in the form of management fees that are customarily paid by portfolio companies to their equity sponsors. Liability can also extend, sometimes surprisingly, to payments that management would not expect. For example, in a recent case, I had an officer of the company use his personal credit card to advance payment for corporate employee travel expenses, and then he would be reimbursed by the company. All of those reimbursements this officer received are potential preference payments that a trustee could try to claw back. Finally, it's important to understand that board members owe a duty of loyalty to the company and must act in its best interest. At times, in distressed sale situations, this duty may conflict with the interests of the private equity firm that owns the company and has employees sitting on its board. Consideration should be given to whether resignation from the board or deference to an independent director is appropriate to mitigate risk for the director and his private equity firm. It's also critical in a distressed transaction to be sure that the company purchased the tail on the corporate D&O policy to provide protection for directors should any claims be made for breach of fiduciary duty after the M&A transaction is completed.